Most people do not know the modes of recovery of premises. Most landlords take laws into their hands when ejecting tenants from their property. Such is being abhorred by the law. The law does not allow self-help in landlord-tenancy relationship. Good day, viewers. My name is Uzoka Charles. I'm the head legal Amuchan Properties. I'm here to educate us on the mode of ejecting a tenant or recovery of premises. First of all, in Abuja, the law that governs the Recovery of Premises Act, though different states in the country has their own law guiding recovery of premises, but in the FCT here in Abuja, what we use is the Recovery of Premises Act. There are issues that arise in tenancy relationship. Most lawyers don't even know this, not to talk of landlords. This issue of recovery of premises has gone a long way. Many people, many landlords have long cases. They've lost money because of that, whereby they pay damages to tenants. But first of all, in a landlord and tenant relationship, I want to talk about the tenancy agreement. The tenancy agreement, this is the agreement that binds the landlord and the tenant. It provides for all the clauses which both the landlord and the tenant is expected to observe. Most tenants don't even bother to look at their tenancy agreement. Whenever they pay their rent, they be issued with tenancy agreement. They don't even bother to go through the provisions. Or even if you don't understand, look for a lawyer or look at a lawyer that can explain those clauses to you so that you understand what that binds you and what you're expected. Now, this will take us to the issue of notices. Statutory notices are the prerequisites that the law has prescribed for anybody that wants to eject a tenant or recover possession in order to avoid the use of force or self-help. These statutory notices is being stipulated by the law, and it is very sacrosanct that it must be followed. Section 47 of the Recovery of Premises Act provide for these notices. We have the issue of the notice to quit. Section 48 also provides for the duration of these notices. If you are a yearly tenant, 6 months notice. Quarterly tenant, 3 months. Weekly tenant is for 1 month, and weekly tenant, 1 week notice. It's better we know this. If you watch, there are some people that have this notion that whenever your landlord want to issue or want to take you to court to recover possession, that the landlord, when you get to court, the court must tell your landlord to give you 6 months notice. That is not true. It is not what the law provides. This issue of 6 months notice is only available to you when your rent is still running, not when your rent have expired. Once your rent has expired, you are no longer a tenant. You are now a trespasser. You are not recognized because your tenancy is for 1 year setting, and at the expiration of your tenancy, it has elapsed. So why there's need for you to look at the provisions of the tenancy agreement. In your tenancy agreement, there might be provision that the issue of the notice to quit will not arise. Rather, what will arise is the issue of notice of owner's intention to recover possession. The law stipulates that before you eject a tenant, the landlord or whoever is managing the property has to issue that notice to quit, 7 days notice to quit. And at the expiration of the 7 days, another 7 days is being issued, which is known as the notice of owner's intention to recover possession, to apply to court to recover possession. Now, there are many instances that will warrant a landlord to recover possession and give you notice to recover possession. Well, for instance, when the tenant is in default of one of the clauses in the agreement, for instance, applying the property or the premises into a use other than what is meant for. Maybe the premises is for residential and the tenant is turning it to commercial purpose. The landlord can have the right to terminate such tenancy. Circumstance where a landlord can issue notice to quit as a portion of time when the tenancy has elapsed and the tenants have not renewed or shown any interest of renewal, the landlord, before ejecting the tenant, must issue that notice, which is provided by, for which is known as notice to quit, and that, which is only 7 days. And at the expiration of 7 days comes the notice of owners, another 7 days, which is the notice of owner's intention to recover possession. If the landlord fails in issuing these notices, his action in court will not succeed. He will not succeed in court in his action to eject the tenant. It is only the court that has that power to eject the tenant from any premises that he occupies, even if the tenant is an illegal occupier of that premises. The landlord that does not have such right to throw him out and throw his things out. He must go to court and use the court to eject such tenants. So this notices is known as statutory notices. It is statutory because the court, that's the only condition that the court has given that you must follow before you eject a tenant from your premises or apartment. Yes, I don't know the experience you've had. I don't know what you've been passing through, considering this issue that I've just mentioned, issue of tenancy, notices in tenancy. But please, always seek for the services of a lawyer or an estate lawyer that will guide you through all this. Make sure that as a landlord too, that this is being observed. If not, when you get to court, you will not be able to eject such tenants. So as you can see, anybody that tells you, go to court, the court will tell them to give you 6 months before you pack out. It is not true, please. Or when you get to court, the court will ask you, when are you going to pack out? And you will tell the court. Anytime you tell the court, that's what the landlord will observe. It is not true. The court is, mind you, the court is not the owner of the property. The property belongs to the landlord. So the court cannot dictate for the landlord how long he will give you. In addition is that once the landlord has done what is expected of him to do by issuing those statutory notices, then I think he will succeed in his process in court. Please, viewers, I don't know if I've satisfied your conscience on this, but at Amcham Properties, we have a team of lawyers that will attend to issues like this so that you don't make any mistake in the issue of your tenancy or your tenancy relationship with either your landlord or the tenant. Thank you. God bless.